Ladies and gentlemen, welcome aboard the Wright Flyer. Today's flight is piloted by Randy Wright, who is joined by his first officer Jeremy Grapington. We know you have a choice when it comes to your radio listening pleasure, and would like to thank you for choosing to fly with the Wright Flyer. Ground traffic control has moved us to the departure lane, so please be seated, fasten your seatbelts, and ensure that all tray tables are stowed in the upright and locked position. We will be taking off shortly, and once again, we'd like to thank you for choosing to fly the Wright Flyer. Now sit back, relax, and enjoy the show as we soar above the friendly airwaves in comfort and style.
Ladies and gentlemen, welcome aboard the Wright Flyer. This is your captain speaking, and I want to take this opportunity to personally welcome you to a special edition of our state-of-the-art radio show. We know you have a choice when it comes to your radio listening pleasure, and we'd like to thank you for choosing to fly the Wright Flyer. What's more, we're confident that no other radio program or venue will fly you over the friendly airwaves in as much comfort and style, nor leave you with an indelible yet pure sense of enlightenment, quite like we can here at the Wright Flyer. So now that you're aboard, please be seated, kick back, relax. We've taxied to the departure lane and are awaiting takeoff clearance from air traffic control. Once they go through all that mindless bureaucratic red tape and regimentation, my first officer, Jeremy Grapington, and I will take you up into the sky. And also, ladies and gentlemen, let's welcome aboard our first Air Marshal, who is here to discuss with us the Privileges and Immunities Clause, especially how it ties in to the Second Amendment rights, and how each state is supposed to treat all state citizens equally and allow them to travel through interstate travel as a right in the Privileges and Immunities Clause, which is primarily in Article 4, and I believe, what, is that Section 2, Clause 2? Section 2, Clause 1. Sorry, I just drew a blank on that. So, Nelson, welcome aboard the Wright Flyer. We are honored and privileged to have you as a guest today.
It's great to be here. Great to be here. Thanks for inviting me on. Nice stuff you got going on here.
Great. So, we know that the Privileges and Immunities Clause is one of those aspects of the Constitution that few people understand, and as Jeremy and I have said on many previous flights, that one of the most important aspects of all our attempts here is to spread knowledge of the Constitution. We consider that a civic duty, a responsibility that all Americans have a fluent and working understanding of the Constitution, because if you don't, you really aren't able to effectively operate within the government and to do your civic duty and responsibility as a citizen, because the Constitution, after all, is the bedrock of every aspect of this great republic of ours. And I think the Privileges and Immunities Clause is one of the most important things that the court truncated with the slaughterhouse cases back in the 1870s, and that really was a mistake on the Supreme Court's part, and of course there are many of them, going all the way back to Marbury versus Madison. But I'm very interested to hear your take on the Privileges and Immunities Clause and how it pertains to the right to keep and bear arms, especially when traveling through the various states with their different local rules and laws with respect to gun ownership, like Illinois having basically you can't have guns at all.
Right, and there are actually two Privileges and Immunities Clause in the Constitution. There's Article 4, Section 2, and then the second one is in the 14th Amendment, Section 1, and of course the second one in the 14th Amendment make it even illegal for a state to pass a law that violates your privileges and immunities of any citizen of the United States, no matter which state you live in. So the fact of the matter is, there is no authority of the states to pass any law that violates your privileges and immunities. You have the privileges, which are not rights, and nor are they. There are things that even aren't privileges, like marriage is not a privilege. No state can abolish a privilege. No state can license a privilege, or they can license a privilege, but they can't they cannot take that privilege away without due process. Such as marriage. Marriage is not a privilege. It's simply a license. The Privileges and Immunities says that you have the privileges and you have the immunity of being arrested or prosecuted for exercising your constitutional rights.
Nelson, what I've always looked at, I've actually come to the understanding, and you can correct me if I'm wrong on this, but I'm looking at privileges as being a license with rights attached to them, previous rights attached to them. So like a driver's license is actually a privilege, and it makes it a privilege because people have the freedom to travel. That's what the liberties entail to that. Whereas, like you mentioned with marriage, marriage cannot be a privilege because there's no previous attached right to it whatsoever.
Yeah, right. As a privilege, it's a permission to do something. It's like to drive. The fact is, a privilege. You have the privilege to drive. You have the right to travel. But the fact is, you can't cross someone else's land without their permission. You can't enter on private property without their permission. And the fact of the matter is, to drive, you are getting a license that consents that you have the authority to use a motor vehicle upon a state or federal or county highway or road. Whereas, the right to keep and bear arms is sacrosanct. You have that right. You are born with that right. No one can take that right. It's unalienable. So the fact of the matter is, the privileges and immunities are really simple. And Randy's right, and that's kind of a pun, but he called it absolutely right on that, is the violations of your privileges and immunities. States cannot license your right to keep and bear arms, nor can they pass any law that violates that. I mean, that's clear in both Article 4 and in the 14th Amendment. They can't pass any law that violates that. Every single state law on firearms is unconstitutional. Every single one.
And, it also ties into the Supremacy Clause found in Article 6, Section 2. And I've always found it interesting how the courts have ignored the Privileges and Immunities Clause, and how, if you actually look at it, it ties in beautifully with things such as the Supremacy Clause, but also with the Full Faith and Credit Clause. Because if you actually look at the way that the Bill of Rights is meant to apply, also looking at the preamble to the Bill of Rights, which explicitly states what they were trying to accomplish with the Bill of Rights, and indeed with the Constitution itself, just reiterating those restrictive and declaratory clauses that they put in, the Privileges and Immunities ties into the Bill of Rights beautifully, but the courts have ignored it. And this goes back to this notion of the courts sitting there doing judicial activism or judicial review, trying to interpret the Constitution in a way that's impermissible, especially when you look at the preamble of the Bill of Rights and also the Ninth Amendment, because those two things are there to state that your unalienable rights can't be taken away, and the Privileges and Immunities Clause should actually be adding to that, giving you an extra buffer, if you will.
Well, correct. On the stances, too, you see that in both the Supreme Court rulings in Washington, D.C. and Chicago, Heller and McDonald, every single justice, except for Clarence Thomas, got it wrong. They kept ruling on the Due Process Clause, which is not, if the government really wanted to use due process, because they said, well, you'd have to arrest and try and give everybody, single person, due process. So what if they want to go that far to do so? They're still violating your rights. Clarence Thomas was the only one that got it right, in fact saying that it was the Privileges and Immunities Clause that they were violating. Even the state, even the Washington, D.C., the District of Columbia, cannot violate your rights under the Constitution.
Right, and, the other thing that ties into that, and what Clarence Thomas was basically pointing to, the courts have been afraid to even look at the Privileges and Immunities Clause since the slaughterhouse cases, where they attempted to state that Privileges and Immunities Clause could only apply to just direct United States citizenship, and therefore the states could rule upon it however they wanted to. And what's interesting about that is that also created kind of the split that we saw with the types of power that they gave the federal Congress via the Commerce Clause and this so-called dormant Commerce Clause in the wake of FDR when he was doing his court packing scheme that really created this two-edged sword of what they were trying to pull off that doesn't fit constitutional muster at all. And it's because they were afraid to act on the Privileges and Immunities Clause and took out the teeth from it, not from it itself, but in the way that the courts and the government looks at it, it really hampered the unalienable rights of American citizens because they wouldn't allow the Privileges and Immunities Clause to be used in the way it's supposed to be. So if you are, say, traveling in Illinois and get pulled over and you have a firearm and that apparently violates their state law, you've got several potential violations there. Privileges and immunities. You also have full faith and credit for any of those states that would have had carry conceal, even though that, too, in the actual proper constitutional context, doesn't pass muster. But you're not giving full faith and credit to those states, and you are abridging the Second Amendment. And it's just, it becomes kind of this tidal wave of problems, and somehow the courts of the several states, as well as the federal courts, just seem to be sitting on their thumbs and allowing this encroachment upon people's rights. It's shocking.
Well, Randy, here's the thing, though. I've looked at each and every one of these court cases. Not a single argument has been made on the Privileges and Immunities Clause. They've never made the argument. If you don't make the argument, then you have no basis to fight on it. I mean, it's like giving up. And the fact of the matter is, I've asked just about every one of these media big heads, Bill O'Reilly, Glenn Beck, so on and so forth, Sean Hannity, even Mark Levin. I asked them, at what point does the federal government violate the Constitution to the point that the federal government itself becomes illegitimate under the Constitution? You can't get anyone to answer that, because they don't know anything about the Constitution. Even Mark Levin cannot answer that. Judge Napolitano refused to answer that. The rest of the point is, if you don't argue the case in court, because, no offense to any lawyers, but they don't know what they're doing. They have no basis on the Constitution because they're not taught constitutional studies, as I was, on how to understand, how to read the Constitution, basic English syntax, which is what it's written in. It's fifth grade syntax. So the fact is, they can't understand what they're trying to fight against. And if they don't have an understanding of what they're fighting against and how to use the weapons that are created by the Constitution to protect your rights, that's what they are there for, as weapons to protect your rights, then they're just throwing everything out the window. And those cases that Judge Thomas ruled in, they made no argument on privileges and immunities. He injected that himself.
Now, I want to bring something else up here, Nelson. This is something that you pointed out to me. U.S. Code, Title 15 U.S. Code, Section 7901, Purposes and Findings of Congress, regarding constitutional rights, so on and so forth, and specifically with the Second Amendment. Now, this is another one of those tools that you're talking about where our own Congress has made law that stipulates exactly what the Second Amendment is. They clarified what it is, and yet still other attorneys and lawyers, they don't want to even use that in conjunction with communities, full faith and credit, so on and so forth. That's another tool that we have at our disposal.
Right, and the problem is that the courts refuse to recognize it. Well, that would be like recognize the same thing is due process. So the courts can say that you have no due process. Let's say it's the exact same thing. It's in the same clauses of the Constitution. You know, the right to due process. And the 14th Amendment says that you cannot have your privileges and immunities violated without due process of law, which means in a court with a judge and a jury and with you with representation from an attorney, if that's what your choice is. But the fact of the matter is, if they, like I said, if they don't argue it, if they don't use the tools that they were given, then they just throw them out the window. And that's violating, that's not only, that's absolutely malpractice, number one. And number two, it's refusal to enforce the Constitution. They take that oath to enforce that Constitution, and they're refusing to do so.
Now, the privileges and immunities could actually be used in conjunction with not only fire, but also, let's say, Obamacare with this punitive tax, which is a bill of attainder. Because when Roberts made his decision, that not once but twice, saying that, well, Congress has the authority to tax people, or the IRS has the authority to implement this and enforce the tax, with it being a violation of Article 1, Section 9, Clause 3, that automatically preempts and creates the situation to where the Fifth Amendment due process clause comes into play, and it's violated. It would also bring in privileges and immunities because you have the right to not have your rights violated, such as you have the right to due process when that's violated. Now, when you speak up against that, you're going to be prosecuted for or penalized because you say, no, I'm not going to have health insurance. You're going to get penalized. So now you're being prosecuted, which removes that immunity of prosecution for exercising your rights.
As I read Obamacare, it doesn't even give you the right of due process. They just fine you. You don't get the due process. You don't get a hearing. They just tack it onto your IRS bill. And if you don't pay it, well, eventually they'll throw you in jail. Maybe then they'll give you due process. But yeah, you have the right to say no. You know, that's the most powerful word in the English language is no. You're going to violate my rights? No. You're going to take my property? No. You're going to endanger my family? No. And that's what the people need to learn. They have the right to say no. And they have the right to say no for whatever they don't want because that government belongs to them. It doesn't belong to a bunch of monkeys up there, 435 monkeys up there. It belongs to them. And it's time for us to teach them that this belongs to them. I spent last week teaching sixth graders that Constitution belongs to them. Each and every word in that Constitution belongs to them. It doesn't belong to a bunch of judges or lawyers or representatives or senators or the president or anyone else, law enforcement officers. It belongs to you. And it's up to you to enforce that.
Right, and it comes down to the whole notion that sovereignty rests in the hands of the people. And I've always gotten into this idea of the tenets of federalism being the full basic building block of the entire country. And it really is a hierarchical system. It's just that the modern government has gotten this completely backwards. The real power rests at the hands of the people. The people then delegate a certain amount of authority to the states that then delegate a certain amount of authority to the federal government through the respective state constitutions of the several states, and then to the enumerated powers within the United States Constitution. That enumerated powers part, and that includes the privileges and immunities, which is designed to protect people from the abuses of not only the enumerated powers, but also some of the plenary powers of the several states. Plenary meaning that they had more original authority because they were closer to the people and therefore had a better interaction with the people. It always gets stronger the lower you get. That was how it was supposed to be, because whatever's closest to the people and what the people exert the most control over is what is meant to be the most powerful. Ideally, the individual person, because that is what builds the entire system. But the Privileges and Immunities was designed to prevent states from denying you your individual rights, your ability to embrace your fundamental liberties. And a lot of what you're saying with the lawyers is they look at these court cases and they see precedent and they say, oh, because there's precedent, we can't argue this. Except, here's the problem. Precedent has no constitutional basis other than what Article 3 says for the existence of the Supreme Court itself. It made no mention of judicial review. That is what the court, or the judiciary, gave to itself. And even if we do use precedent, if you look at the case of Erie v. Tompkins, they said there is no federal common law. So if that's the case, then why are we looking back to the slaughterhouse cases and saying that that is not a reason to raise the defense of the Privileges and Immunities Clause when making constitutional arguments such as those with the Second Amendment right? And it just comes down to a lack of knowledge of what's contained in the four corners of the Constitution. It's a beautifully written document. It has multi-tiers that are designed to protect you from an overarching, overzealous government. But the system just seems to be running around blindfolded without a care in the world as to how this actually works.
Exactly, Randy. And if we look back at the slaughterhouse cases, that was the first attempt to use rational basis theory to adopt anything that the court wants to dream up, to say that, well, we'll have to fit any rational theory I have in my noggin to fit your case. When the fact of the matter is, it's right there in black and white on the 17 pages that most people have the Constitution. And the funny thing about it, the ignorance that most people don't understand, is the Constitution. One of the most misunderstood terms is federalism. You have people, especially in the Republican Party, saying the states can do their what they call laboratories of experimentation. No, they're not. That's a misnomer. That's an absolute lie. When the fact is, we have two sections of the Constitution that tell you supremely what the states cannot do. And that's in the 14th Amendment, and it's also in Article 1, Section 10 of the Constitution. And there's plenty that the states cannot do. It's less than the federal government, but the fact is, people think the states can just get away with anything they want to. They can pass any law, and the fact is, we're gonna pass this Romney Care. Romney Care, it just cranks me up to no end. For the fact of the matter is, the states, it's a bill of attainder, under Article 1, Section 10, the states cannot pass a bill of attainder. It's even a worse bill of attainder than Obamacare, because it clearly says it's a penalty. It doesn't even try to disguise itself as a tax. And the fact of the matter is, they could not pass it, they could not enforce it, and the Privileges and Immunities Clause says they can't do it. And the fact of the matter is, people, I don't understand why people need to, they need to learn the fact that they just say no. And enough of them say no, then the states can't enforce it. That's what people need to learn. Say no to your government, because they don't own you.
That's absolutely true. It's absolutely true. And it goes back to this whole idea of where sovereignty rests. The beautiful thing about what our founding fathers accomplished and what they established at the time of the American Revolution was this marvel concept of what sovereignty is. Think about that. In Europe, sovereignty was defined as, well, a king was called what? A sovereign. Why? All sovereign authority rested in his hands. Our founding fathers said no. Sovereignty does not rest in the hands of a single person. It is we, the people of the United States, we came together and had a social contract. The Constitution is that contract. The states, they don't have rights. The states are a representative body of the will of the people through delegated authority. While the states have what is known as plenary power, that is not absolute power. because the state constitutions are written by the people and the people have direct control over them. That's kind of like the referendum process. That's why if you look at what happened with same-sex marriage and the way that they overturned the propositions in California, that is a violation of the trust of the people and of the tenets of federalism, as Nelson was mentioning. Because when you have unelected judges overturning referendums and constitutional amendments and constitutional definitions, all of a sudden you are taking the people out of it. You are then making it this kind of old style of sovereignty where a man in a black robe all of a sudden gets magical authority to create laws and edicts of his own accord. That is completely contrary to the Constitution and to the tenets of federalism. This relationship between states, federal government, but above all the people, is the most fundamental aspect of our entire system of government. It is what makes us who we are.
We get onto the privileges and immunities. Let's go with the ruling on same-sex marriage. Now, personally, I voted 3 times in California against same-sex marriage. Before I moved to California, I lived in Missouri. I voted once for that. That stupid Supreme Court has violated my rights 4 times. 4 times. They have abridged my vote 4 times. Now, the Justice Department says I have no basis to file an AO 91 federal felony complaint on that, even though 18 U.S.C. Section 241 and 242 clearly say that I do. Say that the Supreme Court themselves has violated my rights. They have used it in color of law. And the fact is, these 5 idiots on the Supreme Court, and remember, Dracula also wore black robes. We need to stick a stake in their heart. For the fact of the matter is, they had no authority to even rule on this case. It went through umpteen courts. When the fact of the matter is, the very basis of the Constitution, Article 3, says that any suit to which the state is a party, only the Supreme Court has original jurisdiction, so they were the only ones to ever hear any argument on the case to start with. So there's another violation of our Constitution. And the fact is, I predicted right off, several months ago, that they would, the judges would start ruling that divorce would be unconstitutional for the fact that states have no authority, if they ruled it was a right, to dissolve a divorce. Thus, it would put people in danger of being in criminal bigamy if they had been divorced and remarried. So there is a bill of attainder right there that the Supreme Court has created in ex post facto manner. This is an illegitimate Supreme Court, has no standing. So the fact is, the states should grow up there and say, we're not going to do it. Now, we go back to 1989, when the federal government said, you're going to change your drinking ages to 21. The state of Oklahoma said, no, we're not going to do it. Because the fact of the matter is, we have the authority under the 10th Amendment to do so. And also, when they abolished prohibition, it said that the states would make the laws on this. So the fact of the matter is, Oklahoma said, we're not going to do it. The federal government said, we'll cut off all your federal funding for your highways. And the state of Oklahoma said, okay, then we'll seize the IRS depot in Oklahoma City, and you won't get a single dime from the state of Oklahoma. How do you want to play that? Well, finally, they voted in, because of the way the Oklahoma laws read, the judge ran out his bill, and the governor ran out his ability to stay in office anymore, and then they voted in a new governor that acquiesced. Here in Arizona, we're on to see like flies. Tell the federal government to go away. You come here and try to violate our rights, we're going to throw you in jail. We're in the state that they operated fast and furious, violated the rights, and killed people. I mean, accessory to murder is still accessory to murder, and for the fact of the matter is, there is no statute of limitations on accessory to murder. I mean, I'm living in the state, they practice fast and furious. most of these, whether people in Arizona like it or not, the fact of the matter is this judge needs to grow a set and say, federal government, take a hike. We're not playing your game anymore. You're done. That's how federalism is actually supposed to work. The states are there to protect the rights of the people when the federal government gets out of hand.
Now, the issue is, and I've had several discussions with other people, the courts behaving the way they do, especially the Supreme Court, is because people have this notion that, well, once they're appointed, they hold that position for life. And I have to explain to them that there's nothing in the Constitution that sets any term limits whatsoever for the Supreme Court except one thing. They hold that office during good behavior. Now, when they say, well, define good behavior, it's not up to us to define good behavior. Congress defines good behavior. And operating outside the scope of the Constitution and usurping the authority of Congress, which Roberts did with Obamacare, and he rewrote the legislation from the bench. He's in the judicial branch, not the executive or the legislative branch. He has no authority to do that. So that is not exercising good behavior. So when they make any ruling whatsoever, no matter how small that ruling is, no matter how innate it may seem that someone's rights are violated, their rights are still violated. And any authority, anybody, any person, like you mentioned, Title 18 U.S. Code Sections 241 and 242, any person or whoever, under the color of any law or co-conspires to violate, impress, threaten, intimidate, or suppress the rights of the people and infringe upon them, it's a felony. It doesn't matter what position they hold. If they're not held accountable to that, then that makes them above the law, which that is in direct violation of the Constitution. Nobody is above the law. That's why the Constitution is written the way it is. So when these people say, well, their lifetime appointments, I tell them, you're full of it. It's impossible for them to hold a lifetime appointment. That's just been the set standard and norm that has been operating in this country ever since Samuel Chase. And I bring up that example. I say they need to be impeached and removed and found guilty, remove them from the bench, and when anybody is impeached, according to the Constitution, Article 1, Section 7, I believe, anybody that is impeached, I could be wrong on the article,
6.
But Article 1, Section 6. If you're impeached from holding office, you are no longer allowed to hold any office of public trust under the United States. And that's where people don't understand. The public trust is the delegated authorities, the people allowing them to hold office. That's where our vote comes in. That's why our vote is so sacred. And to allow that to happen, and then to hold public trust, you are essentially abridging the votes of everybody that voted in that district or even in the country. Alcee Hastings is a prime example of this. He was a federal judge that was impeached and convicted and removed from the bench. He is a sitting U.S. senator from the state of Florida, I believe the 20th district. How is that possible? It's because people allow it to happen. People want to blame the government for everything, but you know what? We the people, we have to take a step back and we have to start pointing the fingers at ourselves too. Because we're allowing this to happen, and it's time for us, like you said, Nelson, for them to say, no, it's not going to happen anymore. History is repeating itself. We did this with the King of England. When we broke away from them, declared our independence, we told them no. History is cyclical. It's coming down to that point again to where we must stand up and say, no, it's not happening.
Right. And the fact is, I mean, it's so dangerous to the people when the government is out of hand. I mean, it belongs to us. But the fact of the matter is, it's just letting if you own a house and just letting your house just go to havoc to where it fell down around your ears, it's your own fault. You don't fix it. And unfortunately, the education system. I came from a state that requires a 100-question U.S. Constitution test. And you have to get 75% on it to pass 8th grade to pass high school and to graduate from any state funded university. I'm the first one in the history of Missouri to ace it 3 times. Not to ring my own bell wasn't that hard. If you learned it in 8th grade, you've learned it for the rest of your life, it would seem. But the fact is, guys, that should be required in every state in this country. The Constitution is that important. It's the most important thing in the really comes down to it. It's the most important thing in the world. Because if they take your rights away from you, you have nothing else. You have no property, you have no freedom, and you have no family. And for the fact is, the most important article or amendment in the United States Constitution, going back to reverting to the original topic, is the Second Amendment. That is the very most important article or amendment in the Constitution. For the fact is, they can't take anything away from you if you enforce your Second Amendment rights. And when you lose that right, you've lost them all the rest of them already. You might as well kiss them goodbye, because you can't defend them. You can't defend them with your First Amendment, because they'll just hold a gun to your head and take them away. And the fact is, we need to push. And I'm with the Arizona Citizens Defense League. I'll be addressing them October 10th on the Privileges and Immunities Clause. And the fact that David Codrea, who's a very good gun writer on gun rights, it will also be, he's the main speaker there. We're going to be talking about the privileges and immunities of the citizens of the United States. They cannot infringe on those privileges and immunities. You are immune. And that's what we need to drive into. How many people do you know do not understand the word immune? That means you cannot be arrested, you cannot be prosecuted for exercising your civil rights. You can't be. And for the fact is, they try to do that, that's a violation of your civil rights to go to prison. But unfortunately, we have a administration right now, and we've had several actually. The Bush administrations were no better at enforcing the civil rights. In fact, if you look at the Heller decision, the Heller suit, George W. Bush's own Solicitor General, who is his representative lawyer from the White House, wrote an amicus brief against Heller. So anybody that thinks that George W. Bush was for your Second Amendment rights has no idea what they're talking about. George Bush was not a friend of the Second Amendment. We haven't had a friend of the Second Amendment since not Reagan, Calvin Coolidge. In fact, we haven't had a good conservative constitutionalist since not Reagan, since Calvin Coolidge.
Yes, and Coolidge really did represent the idea of going back to the proper scope and application of the United States Constitution. And Nelson, you pointed to this fact that, yes, the immunities part of the Privileges and Immunities Clause reiterates this one fundamental aspect of the United States Constitution and how it was inspired that none of the current educational systems tend to focus on. My law school did, but that was a rare exception. And that's this notion that if you actually look at the Constitution and how it came to be, it is actually natural law. They are saying it is not government that gives you rights. It is not even the Constitution that gives you rights. It is the Creator. Those rights that are endowed to you by your Creator that only the Creator has the authority to take away. And the government really doesn't like this, because it means that they have very little control. And that's the danger we run into with, say, like any of these cases with same-sex marriage or ruling that marriage is a right, where they dig into the penumbras of the Constitution to find things. It's a danger because it is all of a sudden taking away this fundamental bedrock principle that those rights are endowed to you by your Creator, that no one can take away those rights. That's what an unalienable right means, that it just cannot be taken away. And that's why they're fundamental. They're fundamental to your existence as a citizen, but it also means that these rights are coupled with duties. And the primary duty, as you pointed to with the Second Amendment, is you have to be able to defend your rights. You have to stand up for them and be willing to take accountability for it. Self-respect, self-accountability, and self-authority here is important, because if you think about it, the government serves us. It's supposed to. It hasn't in a while, and it is all because we have been slowly allowing ourselves to slide away from the proper scope and application of the Constitution as a whole.
Well, and you get to the fact that the Bill of Rights itself is derivative from the Privileges and Immunities Clause. The fact of the matter is, when Madison wrote the Privileges and Immunities Clause, Mason and several others had doubts that the federal government would ever enforce that or even honor those, or the states either. So the fact is that they wanted something specifically laid out, that this is what they can't do, this is what they can't do, this is what they can't do, and not leave it up to, oh, well, these are privileges and immunities. Well, what's a privilege and what's going to be an immunity? What's going to be a right and what's not? Well, there they are right there. And then we get to the Ninth Amendment. People do not understand the fact that all rights in the Constitution are enumerated. There are no unenumerated rights. That is a progressive idea. For the fact is, then we can name anything a right we want to, get away with anything we want to, and that's not the way it works. That's why we have an amendment process. It is to recognize rights that we hadn't previously thought of or did not exist because of technology or anything else that may have come up in the future. It's to address the future problems on rights. And the fact of the matter is, the Bill of Rights is derivative of the Privileges and Immunities, and thank God that Madison acquiesced to Mason to write the Bill of Rights, but still the Privileges and Immunities enforces the Bill of Rights, makes it even stronger, and then you have the 14th Amendment Privileges and Immunities, which enforces it even more strongly on the states. And the fact that the states cannot violate your privileges and immunities, you have people out there, pundits, who say that, well, the states aren't held to the Bill of Rights because those are only for the federal government. No. They're wrong. They have no idea what they're talking about, and they basically need to be turned upside down and filled with concrete, because their understanding of the Constitution is pretty much nil. And you get judges that do that, you get politicians to do that, and you get your pundits. They have no idea what they're talking about.
Well, you mentioned with the Ninth Amendment, and I think what troubles people mostly with that is their lack of understanding of what the word construe means. They don't understand that the word construe is the same as interpret. They seem to not be able to read a dictionary in most cases. And as you said, also, all rights are enumerated in the Constitution. So when a court makes a ruling and they say, well, this person's rights were violated, and because this ruling happened this way, now automatically, well, this person's rights are now violated because of the ruling, but we've made our ruling, so it has to be that way. That's a blatant disregard and violation of the Ninth Amendment, because you cannot protect one person's rights and allow those rights to be used to disparage the rights of others. I use the example oftentimes with the Second Amendment. You have the right to keep and bear arms. And this goes back with what Randy was saying is a personal responsibility and duty and the willingness to be held accountable. You have the right to keep and bear arms, but the second you use a firearm to violate the rights of anybody else, you're no longer exercising your rights, you're committing a crime. Therefore, your right it's been suspended. And it is continuance of suspension with due process. That's how that works. Freedom of speech is another one I use. Yelling fire in a crowded movie theater. People say that's against the law. You can't do that. Wrong. It's exercising your constitutional rights of free speech. Now, where the responsibility comes in, if everybody in that crowded movie theater just sits there and does nothing, and there's no injury, there's no damage, nothing happens, where's the crime that has been committed? Because in order for a crime to be committed, there has to be injury or damage sustained. Now, if somebody gets up and panics and then causes other people to panic and people get trampled to death, now because you exercised your right, you caused the rights of other people to be damaged. So that's where the crime comes in. People don't seem to understand that. They want to interpret what the rights really mean instead of reading them for what they are. Like you said, it's written in black and white. A fifth grader can understand it, and as Groucho Marx would say, quick, someone find me a fifth grader.
Yeah, absolutely. Absolutely. Guys, I'd like to go on and on about this. I'm sure I could go for hours, but I'm about to run out of battery power on this phone here. And I think we've covered about as much as anybody could understand without getting so far into the weeds that they can't see over the top of them. I sure do appreciate you guys having me on your show. It's been a great conversation. And you guys, I really am proud of you for having this show and trying to educate the people on the Constitution, which is my favorite subject. And more power to you guys.
Well, we appreciate it, Nelson, and don't think that this is the last show that you're going to be on, because you will be on many, many more. That's a fact and a guarantee.
Thank you, Nelson. It has been a pleasure, and you will always be our first air marshal. All right, folks, we're going to go ahead and pass around the last round of alcohol before we take it down for the descent. I, again, am Randy Wright. I'm your captain. My co-pilot and first officer is Jeremy Grapington, and we were joined by the first marshal, Nelson Ward. Thank you again for choosing to fly the Wright Flyer. We'll see you next time.